Okay. Good afternoon. Good afternoon, everyone. Um, my name is Winfred Narr. I am the program manager for the Center for Financial Empowerment here at the Department of Consumer and Business Affairs. Welcome. I appreciate you all taking the time out of your lunch to come and join us and here to listen to some very impactful information. So let me start off by saying that this meeting is going to be recorded. It will be available after the meeting, and then we will also have opportunities to leave messages via chat or Q&A. All right. And so let me start off by just introducing um, the DCBA and Children and Consumer and Business Affairs and the Center for Financial um, Empowerment Unit. Um, Let me move to the next slide. Okay, so again, I'm from the Department of Consumer Business Affairs. We serve consumers, businesses, and communities through education, advocacy, and complaint resolution. Our mission is to create a fair and vibrant marketplace for consumers and businesses by assisting in these following areas: consumer counseling, investigations, small claims, dispute resolution, wage enforcement, wage empowerment, tenant protections, foreclosure prevention, and immigrant affairs. Um, we do a lot. We're a very small department, but we do a lot, and we help um, many LA County, thousands of LA County residents, and empowering them and helping them to become more educated on their rights and ways to get through um, uh, through our services. Now, the Center for Financial Empowerment, that's the division that I'm in. We are conveners. We help build capacity for nonprofit profits and businesses and partners that we work with, and we advocate for LA County residents to create a better, more healthier, more educated county residents, especially for those who have not received the services that many others who have the luxury to receive. So we focus on Black, Indigenous, and people of color, and to help build their economic resiliency. Okay, so I am now going to hand over this presentation to our two subject matter experts. They're attorneys, Anna Dar and Dominique Sands-David. They're legal attorneys from Tzedek Services, and this is going to be a partnership that we're having together. This Leaving a Legacy program partnership that we're having is going to be, we want to look to subject matter experts who know how to assist and help those who want to provide some sort of legacy for their loved one. And so this is going to be a great opportunity, and you guys are going to get some very impactful information. So please sit back, and Dominique, Anna, I'll let you do your thing.
Hi, everyone. I'm Dominique, and we're here to talk about Leaving the Legacy program, about why estate planning matters, and then we'll take some time to review and go over different estate planning tools.
Hi, and I'm Anna, also from Tzedek. So yeah, this is a little overview of the Leaving a Legacy program that we are very happy to be starting with our partner, the DCBA. So we're going to talk about this project, which is, it has a goal of, right, we want to work on creating intergenerational change by preventing the loss of home ownership, and we want to create access to estate planning services for Angelenos. We at Tzedek, we're one provider of these services, and we're also going to be joined by St. John's, as you see on the flyer here, St. John's Community Health, and they're going to start, I believe, tomorrow providing services as well. And after that date, any applicants to the program would be directed to either Tzedek or to St. John's based on zip codes. So we currently at Tzedek, Dominique and I, we help families plan for the future, right? By doing estate plans so that their heirs can inherit from them without having to go to court, without having to go through probate. We also help people figure out how to collect their family's assets after death if they didn't plan in advance. And another important part of our work in estate planning is elder abuse prevention, right? Hopefully by having planning documents in place, people are less likely to fall victims of scams and things like that. And today we're going to talk about succession or estate planning and why it's important for everyone to think about.
Okay, so just so you know, we're going to use the word succession planning and estate planning interchangeably here. They mean the same thing. So estate planning is making a plan in advance about your health care and finances and assets in two situations. The first situation is during your life, but if only if you become incapacitated or unable to make decisions for yourself. So for example, if I got into an accident and stopped being able to make my own healthcare decisions or may pay my bills, my estate plan would say how I would want things handled and who I would want to make the decisions for me while I was unable. So who could pay my bills, who could talk to my doctor, insurance company, government agencies. And then estate planning also allows you to make a plan for how you want your things handled after your death. So after your death, the decisions you'll plan for will be about what you want to happen with your remains and who gets your stuff, maybe who you'd like to take care of your minor kids if you have any. And after death, most people have a few bills to pay, accounts to close, and some things, whether traditionally valuable or not, that they want to pass on to someone. It doesn't have to be a lot to think about your estate planning.
So there are a lot of reasons, right, why we want to plan in advance and why we want to do estate planning. And this is just a little image here of some things that are really important to most people, right? One big thing is autonomy, right? We want to make decisions for ourselves. And even if we need help, we want to be in charge of that. So if we make decisions now about our future care or our finances, it's a very empowering thing to do and a way to keep control. And you can always change your mind in the future. So if you do documents today, you're not locked into those forever. You can always edit and you can always update them and change them in the future, which is very useful. Legacy is another thing, right? It's important for us all to leave something for our loved ones when we pass. Like it doesn't matter how much we have. It could be a little bit of cash or a house or, our favorite piece of art or jewelry or something like that. And planning in advance makes it a lot easier for us to pass that down to our family or loved ones to get them in the future. Um, Doing planning also is very helpful in avoiding costs. If you have a plan in place and you have documents, you can really avoid a lot of court intervention. And as we all know, right, court costs and lawyers are really expensive and it eats up a lot of someone's estate if it has to go through it. So by doing planning, you end up keeping more money in the family instead of it going to courts and lawyers. And also some government benefits like Medi-Cal, they won't file reimbursement claims against an estate if it does not go through probate. Another objective of estate planning is, like Dominique said, right, dealing with any future incapacity, and it also makes dealing with death down the line easier to manage for family members. If there's a plan in place and a thought through situation, then it's a lot simpler for the people who you trust if they have legal authority to carry out your wishes, if they know what you would want them to do, and without having to ask for court involvement and second guessing, what you would want. And finally, planning in advance can help protect any minor or disabled adult children because you can nominate guardians and decide, who will manage inheritance and things like that.
Okay, so I think there are two main challenges to estate planning. The first is not really wanting to think about your death and disability, and the second is a matter of education and resources, and that's sort of where we're helping to change things in Los Angeles. I know many people are reluctant to do estate planning, to think about it or talk about it with their kids because it involves thinking about death and disability. And because they don't want to be a burden to anyone. I've had some clients say like, well, if I talk about it, I'm going to hasten it. And it's like, well, I mean, I understand that, but you know, it's going to happen. So best to just get it all out in the open. When discussing these documents with clients, I like to focus on how it's really about retaining control of what's going to happen in the future by making your wishes known now. Um, so, you know, before our program, there weren't many free legal services for estate planning, so people would generally have to have the money to consult legal professionals about their options. Some people used like LegalZoom or other online document preparation services, and those can work for some people, and for some people we see it's a real disaster. Um, what's interesting is that only a third of Americans have an estate plan, and there is a significant disparity in access to estate planning among different communities. So, you know, we're hoping to change that with our program. By getting people the education about estate planning and then actually doing estate plans for people who need it.
So we kind of just wanted to go through what can happen if we fail to plan ahead, if we don't do anything, right? I mean, sometimes, you know, in some cases things work out anyway, right? Even without planning, but far more commonly, we people run into very common issues over and over again, which we see a lot of from our work. So I'm just going to go through a little bit, you know, what can happen if you don't have any documents before death and then after death. Like, so if we go through before death, right? So in a scenario where I live in an apartment, I have two kids and I have a bank account. Everything's fine, I'm plugging along. But now I lose capacity, right? I maybe end up in a coma or I can't I'm not able to handle my own finances. And if my accounts are just in my name and only I have access to them, then my kids could try to help, right? But they would likely end up stuck because I never gave them legal authority to manage anything. Like they can't just walk into my bank and say, you know, I need access to my mom's account to help her deal with things. The bank's not going to let them have that. So then how would my rent get paid, my utilities, and how would they even figure out what my bills are? And who could speak to my doctors, who could help sign off on a surgery or any treatment if I can't speak for myself? All of these things, right, could be pretty easily avoided. Um, so if there are no documents, then my kids or whoever is trying to help me would likely have to go to court and either, you know, get some sort of court authority to authorize a single transaction, like accessing my bank account to pay my rent, or they would have to try to file for a full conservatorship to take care of everything if this isn't just something temporary. But if I just had a simple power of attorney or advanced healthcare directive, that could have all been avoided because I would have had a legally appointed decision maker to actually step in and speak for me. And then, of course, for added complications, right? Say both my kids are trying to be the person who makes decisions for me, then they would also have to argue with each other in court about who is best suited. So that can end up in a big, ugly fight. And then let's look at a situation after I pass away, right? It won't affect me because I will be gone, but it would really impact my loved ones and my things. So say I passed away and I owned a house, and again I had two kids, and I didn't do any planning, no trust, no will, nothing like that. That's called dying intestate. So now California law would determine where my things go. So even if one of my kids, say one of my kids had been abusive and had stolen from me in the past, and I wouldn't want them to have anything, if I didn't write a will or put this down in a legal document anywhere, right, then they'd both be entitled to half of what I have through intestate succession. Um, and since I didn't have a trust or any setup like that to pass ownership of my house, then it would have to go through probate, which means the court would have to supervise distribution of the estate through the probate process, which we'll talk about a little bit more later, but it can be very costly and time consuming. You know, in a probate case, an executor would be appointed by the court as a personal representative. They have to collect all my assets, pay the debts, distribute the remainder of the estates to the beneficiaries. And it all has to be supervised by a court, which makes it take a long time, generally about 18 to 24 months. And it involves pretty significant fees that are all set by statute, and it's based on a percentage of the value of your estate. And it's based on the gross value, which is important, right? So if my house was worth $800,000, even if it has a $700,000 mortgage on it, the fees are still based on the $800,000. So without any planning after death, right, your assets could go where you don't want them to go, and your family may have to go to court and file a case, even if the estate is smaller, and things can get complicated, and it can just lead to a lot of fighting and confusion.
So I wanted to talk about joint ownership. Some people think that putting a family member on title to their home or bank account is a good planning tool. And you know, it might be for some families. However, there are risks and consequences to putting someone on title instead of doing estate planning. So I'll give you a few instances when we see this. So let's say I put my son on title to help me manage or help me qualify for a refinance or to qualify for initial loan. So it'll be like, you know, it's really my house, but now my son's name is also on title. Um, so that we see that a lot, right? People need to refinance, they need to qualify for the refinance, and so now two people are on title to the house, even though it's really just my house. Or say, you know, let's say that I decide I want my son to help me pay bills after I get a hip replacement, so I put him on title to my bank account. Now we're joint owners of the bank account. And this means for the house and the bank account that I own an undivided interest and so does my son. I own the whole thing and so does my son. And that means that, you know, we have the same rights with regard to the house and the bank account. We can both live there or use all the money. We can both sell our portion of the house. We can, let's say you know, like my son gets into an accident and there's a judgment filed against him and then he doesn't pay and then they put a lien on the house. All of these things can happen to me just because I said, well, I want him to, just in case in the future, I want him to be able to manage this for me. So, you know, there's a better way than putting someone on title as joint tenants in order to get help in the future if you need it, and that is through estate planning.
And you can't get rid of them. If you add someone as a joint tenant, they have to agree to come off of it again, right? You can't just say, never mind, I'm taking you off, because they own it with you. So
Right.
that's another thing to think about.
Or when you pass away and you know your son's on title to your account, he gets all the money in your account, even if you wanted it to go to your 4 kids equally. So there are consequences that people should just be aware of.
All right, so we've already kind of talked a little bit about some of these, right? But we're going to go through each of these 5 main estate planning tools that we use for our clients at Tzedek. Especially for folks who don't have a lot of assets or very complicated estates, because we don't help people with large estates with investment properties or business ownership or things like that. So again, all these documents are things that you can change so long as you have the capacity to draft documents, which we'll talk about. But yeah, we'll go through each in turn, and we can start with the Advanced Healthcare Directive. This is a very important document. I like to start with this one because this is one that everybody should have in place, regardless of your health, of your age, or your situation. We all should have this. This is a legal document, right? It allows me to give someone else the power to make healthcare decisions for me if I'm unable to, for whatever reason. That person is called my healthcare agent, and I'm called the principal. Second, in this document, I can give my agent, or if they're not available, or if I don't have one, my doctor, specific healthcare instructions, and that includes end-of-life instructions. And this document can be revoked or changed at any time. My agent's authority to make decisions for me here can begin whenever I want it to. It can be either immediately, or I can say I only want them to be able to help when I'm no longer able to make decisions for myself, when I don't have the capacity to. You can appoint any adult that you trust, a family member, a friend, neighbor. It can't be a medical provider, and they have to be over 18. And this document, our document, also allows you to appoint 2 alternate agents in case the first one is unavailable. So for example, my spouse is my agent, but say he's out of the country or something, or can't be reached, then my backup agent, my mother, would have the authority to step in and make decisions for me. This is a pretty simple document to complete. You don't need a lot. You need a pretty low level of legal capacity to execute the document, meaning you need to understand, that you're giving someone the power to make that medical decisions for you, and you have to be able to communicate who you want to give that power to, essentially. So it's not a super complicated decision. We help people who have, mild to moderate capacity deficits execute this document. It's also known as, you've probably heard the terms, living will, healthcare proxy, advance directive. They're all this document. And just to note, because this comes up a lot, if you don't have a suitable person to appoint as an agent, right, it's still useful to do this document because you can still leave healthcare instructions. So you can essentially, this document can speak for you if you can't speak for yourself. And on the flip side, some people are not ready to make that don't want to leave healthcare instructions, are not ready to make that choice yet, but they have a trusted person that they want to act as an agent. So you can sort of do one or the other. It's good to do both, but if you can't, then you can still do the document. Based on this document, my agent, so whoever I appoint, can basically decide anything that I can currently decide, right? They're really my surrogates. They step into my shoes and speak for me in medical decisions. They can get confidential information from my providers. They can, choose hospitals, authorize surgeries, or all the things that I can do. There are certain things they cannot do, like they can't place me in a mental health facility or in a locked dementia facility if I don't want to go. And they can't make any decision for me if I disagree. Even if my capacity is questionable or lacking, if say Dominique is my agent and she said, well, Anna should have this, surgery, and I say, no, I don't want it, then I'm still in charge. So you're not giving away your own decision-making power by completing this document. Again, it's very important. I think probably a lot of folks are familiar with the Terry Schiavo case. I'll give a very short summary of that and just explain why. It's just a good illustration of how wrong things can go if you don't have this document completed or a surrogate appointed. That was the case where a young woman was in an accident and ended up suffering brain death, and she was placed on life support. She was married, but she did not have a healthcare directive, and then it ended up that her spouse and her parents essentially fought it out in court for, I believe it was 15 years, about whether she should be kept on life support or taken off, and who should make the decision. And that's kind of the absolute worst case scenario, obviously, but it's just very important. It makes it a lot easier for everybody involved if you have put someone in place to make these choices for you.
Okay, and then I'm going to talk about a power of attorney for finances, and it's similar to a power of attorney for healthcare in that you designate a trusted person, your agent, to manage something for you, but this time it's your finances. And it can be just part of your finances, like just one bank account, or it can be all of your finances, like your house and your investments. And with the power of attorney for finances, you can have it be effective immediately. So if I wanted Anna to be able to pay my bills right now because I'm leaving the country for 6 months, it would say, she can have authority to access my bank account from now until 6 months from now. Or my power of attorney can say, I want Anna to be able to access my account only when a doctor says I lack the capacity to manage the account myself. So it's very flexible. You can give your agent limited power or very broad power. So as with the Advanced Healthcare Directive, you can change or revoke the power of attorney for finances at any time, as long as you have the capacity to understand that you're revoking it. And we're very careful about doing financial powers of attorney for people, especially those who have a house, because we've seen clients who unwittingly sign these and then the abuser takes out loans on the house or sells the house and it's all in the client's name. And so once anyone catches on, it's too late to fix and get the house back. So it's important to have a very, very trusted person serve as an agent for your finances. Um, and I'll just say something quickly about the difference between a power of attorney and a conservatorship or an adult guardianship. So you can only give a power of attorney. You can't get one. So we get a lot of calls from people, adult children, saying they need a power of attorney for their mom. And we have to tell the children that we need to talk to their mother. Their mom has to know what the power of attorney is and that she wants to make her adult children her agent. So like if mom has Alzheimer's and couldn't understand what it meant to give her daughter a power of attorney, then daughter would have to go to court and file a conservatorship petition. And that's where you ask the court for authority to make decisions for someone else. It's not just, your mom gives it to you in advance, approves it in advance and says, okay, you can do this when I lack capacity. It's really, mom didn't do that. And now we have to get authority from the court to make decisions for mom. Um,
Right. So now we're moving on to wills. Oh, 1 second. Sorry. I have frozen. Okay. So a will, this is obviously a document that everybody has heard about. But this, just to go over kind of the legal basis for a will, it's a document that allows you to designate the people who should receive your assets when you pass away. It doesn't give anyone the power to make decisions for you while you're still alive. It's not a mechanism to avoid creditors. In terms of the capacity you need, so the understanding, to create a will, it's again it's very low. You just need to know what you own and where you want it to go when you pass away. That's it. You don't have to be able to remember new information or to have good short-term memory or anything like that. It's a very low level of capacity. Unless it's a really small estate, a will would usually go through probate, right? And that's what we talked about before, the legal process for distributing a deceased person's property with court involvement. But a lot of things are not actually covered by a will. They're called non-probate assets. Those are things like life insurance or retirement plans that have a pay on death beneficiary. Things owned as joint tenants, like Dominique covered, right? If my house is owned in joint tenancy, when I pass, my share automatically goes to the other. Things owned as community property, things in a trust, all those things are not covered by a will and they don't pass through probate. So um, if I've put a beneficiary on my bank account, say I put Dominique as my beneficiary on my $100,000 bank account, but then I also wrote a will saying I want, my whole bank account to go to my brother, then my brother would be out of luck because it would automatically pass through the beneficiary designation to Dominique and not to him. Like we said before, if there's no will, then you pass intestate. That doesn't mean that the assets go to the state, right? It just means they get distributed per statute. So what California's law outlines who should get what if you pass away without a will. Next slide.
okay, so we're going to talk about the trust. Just it's going to be only the revocable trust. There are other trusts that people use for other reasons that I just don't know about. The trust is a document that you create, and it's like sort of like a contract that you make with yourself. And it says, I want to put my assets in the name of this trust, and then I want the trustee, that would be me at first, to manage the assets for my benefit while I'm alive. And when I die, then I want my new successor trustee, the person who takes over, who I've appointed, to distribute my assets pursuant to these instructions that I've made. And so with the trust, you avoid probate, you avoid going to court, you avoid potential Medi-Cal recovery, and you still sometimes have to do maybe hire an attorney afterward, maybe do some trust administration, make sure, specific notices get out to people. There's a process, but it's going to be a lot less expensive and time consuming than going through court. With a trust, you don't avoid, creditors. It's not like if I put my house in a trust, then my creditors can't come after me and collect. It's not for that purpose. It really is just for the purpose of saying, this is what I want to happen to my stuff after I die, and I don't want the court to be involved at all. So a trust, it can be a little, it's sort of an amorphous concept, and I've tried to put like a little icon here to show you what it is. It's oops. Okay, so I'm going to give you an example, like when I put my house in a trust. Okay, let's say I have a house. Here's my house. And I want my house to go into a trust for my benefit while I'm alive, and then I want it to go to my daughter once I die. So the house right now is in just my name, Dominique Sands David. I own the house. When I put it into trust, I sign the contract, which is the trust, and then I create a deed from myself to myself as trustee, putting my house in the trust. So let's say my trust is called the Dominique Sands David Revocable Living Trust of 2022, and I will then sign a deed saying that the owner of the house is now me, but as trustee of my own trust. And it's all very interesting, and I really feel like I couldn't understand it for a long time, but it really is just a piece of paper and a title transfer.
All right, so now a little bit on the transfer on death and beneficiary designations. These are very handy, right? They're a method of transferring property, which are an alternative to a will or a trust. You avoid court administration when you do these beneficiary designations, generally, unless something goes wrong, obviously. There's never, you can never guarantee anything. But depending on the type of assets that you're going to transfer, it usually just involves a really simple process of filling out a beneficiary designation form, which is provided by the holder of the property. So say my bank, right? I open a bank account, there should be a form called a beneficiary designation or pay on death or form. And there you indicate who you want to get the asset when you pass away. And like I said when we were talking about the wills, beneficiary designations take precedence over a will or a trust. So even if I write a will saying everything should go to my kid, if I put a beneficiary designation on my bank account for the benefit of somebody else, then they get the money, not whoever is supposed to get it in my will. A lot of assets can be transferred by this kind of designation. Things, a home, real property, mobile homes, cars, bank accounts, life insurance, retirement plans, annuities. And after you pass away, technically, all a pay on death beneficiary would need to do to claim the money from the account is to show the bank a certified copy of a death certificate and then proof of identity. And then they would be issued a check. Then a little note here on transfer on death deeds. I think that's also something that you may have heard about. That's a way to do a transfer on death on real property. It's a little more complicated than just a simple form that you do with the bank. And it can lead to some other complications. There are some limitations on all beneficiary designations, right? Because it depends on the institution that you're dealing with, like the bank, right? Some of them don't allow things like contingent beneficiaries, meaning I can't list a backup. I could only say, I want this account to go to Dominique when I pass away. So if she predeceases me, if she passes away first, then that gift would fail and it would go back into my estate, and I would have to, it would have to go be dealt with in more complicated ways. And sometimes you can't divide things unevenly. Like I can't say I want 30% to go to this person, 20 to that person, things like that. It's just even split. So it depends on the account holder. Some common problems people run into here is that you forget to actually put a beneficiary on there, or they have already, like I said, they pass away before you. People who put my estate as the beneficiary, that's kind of just like not putting one at all. And also just outdated beneficiary designations, right? If I opened my bank account back in like 2020 or 2002, I might have put, some good friend of mine back then. And since then, things have changed. Like maybe I'm not even in touch with this person anymore. So it's really important to check all your accounts, your IRAs, 401k, all those things, and make sure that it's actually still correct. And then finally, I wanted to do a little note here on digital assets, because this is really important these days. And I think a lot of us have not done this. Common digital assets like your Apple account or your Google, Gmail, so any social media accounts, they all have their own processes in place to designate who should get access to your account after you pass away, or if your account should be deleted, whatever it may be. And if you don't put this in place before you pass away, family or loved ones may have to go through a really lengthy process to get access to your accounts, like going to court and going through a full probate just to get into your Apple account to keep your photos or whatever it may be. So it's very helpful to actually go through and set those up now.
Yeah, we've realized that the technology is way ahead of the laws dealing with the technology. So some countries or, I don't know, some states maybe have easier ways to get access to, your loved one's digital assets, but we don't in California. So people are running into problems. Okay, so, we've made planning seem great, but there are, of course, some limitations to planning. We all know that you can have all these legal documents in place and still get swindled or scammed or taken advantage of. And so our recommendation always is that, the best thing you can do to avoid becoming a victim of a scam is to make sure you have people in your life um, who are in your business and checking in on you all the time. Neighbors, social workers, family, or friends. Um, maybe put someone on your bank account to receive copies of statements only, right? So they can't access the money or use the money, but they can at least check up on your bank statements and see if anything strange has happened. My dad actually just listed me on some account as someone the bank would contact if my dad pulled out a certain amount of money, right? So like if he asked for more than $1,000, then they would call me. But I think the more educated people are and the more they think about estate planning or advanced planning, they'll be less likely to be taken advantage of in the future.
So a common problem is, right, if there's nobody that we have in our lives that we trust enough or that we want to be agent for us or be in our, know everything about us or make decisions on our behalf, there are still a lot of things you can do, even if you don't feel like you have someone that you want to appoint as an authorized decision maker. So these are just some samples, right? You can do an advanced healthcare directive with a lot of decisions already made, with a lot of choices outlined, very detailed version. Um, and you can make sure you have all your beneficiary designations set up so you don't have to have an executor of a will. You can set up auto pay for bills and things like that. So things will keep going even if you're maybe out of commission for a little bit. And also just getting connections with organizations and social workers who check in on you, set up a program to get weekly check-in calls, things like that, get connected with a senior center. And like Dominique just said, the information only power of attorney with a bank is very handy, right? Even if I don't want someone to make transactions for me or deal with my bank account, maybe someone who gets copies of statements or just has access to find out if any big withdrawals are being made. That's a great check just to have in case something is going on. And of course, right, you can hire a professional fiduciary if you have the funds to do so. That's basically like an agent for a power of attorney, but they're paid. But they have a fiduciary duty, to you, of course. So they will really keep a good eye on things and handle your affairs. But again, you'd have to, they're not free. So there are a lot of things that you can do right away, things to think about doing right away that are simple that you can do to just give some peace of mind. If you get Social Security, there is now a advanced rep payee set up. So you can call the Social Security Administration and set up a representative payee, somebody who would receive your Social Security payments on your behalf, should you need one in the future. You don't have to set it up now if you don't need it, but it could be it basically pre-sets up that process so you don't have to deal with it if you become incapacitated or not able to manage Social Security, then someone's already in place. Like we just talked about, right? Something to do today is to check in on those beneficiary designations on all your accounts. Make sure they're correct, make sure you have them, so that you know what's going on there. We have a self-help packet, how to do a advanced healthcare directive, and we also certainly assist with them. But those are really handy. And if you've already done this, if you already have an advanced healthcare directive, today is probably a great time to look it over and make sure it's still correct, right? That you still, whoever you appointed as agent is still who you want, and all those things. And also look into those digital assets, and set up the legacy contact on your social media or your other accounts, so that that's all ready to go. It's never a bad time to get started, right? And it's always easier to do it now, to start looking at these things and thinking over the big picture rather than waiting until something happens or there's some sort of crisis looming.
Okay, so, connecting to our program is simple. If anyone is interested in learning more, you can visit the Tzedek landing page, and I think we have a link in here, right? And remember that our services are free, and we have another partner, St. John's, who will be joining us very soon. They're the center in South LA, so if you live in that area, you can go ahead and click the DCBA link here, and you can find more information on St. John's program. And so we want to thank the DCBA, and we will turn the mic back over to them, and so they can fill in on anything we've missed.
Thank you, Dominique. Thank you, Anna. Much appreciated. And we look forward to hearing from you all over throughout the end of the year, and also going into 2024. And so this is the end of our webinar today, but I definitely want to make you all aware that we will continue this partnership and providing education to our LA County residents so that we are empowered to help ourselves. And Tzedek and St. John's will be assisting in providing that outreach to all of us. I see something in the chat. How soon, from Chinwei, saying, how soon can I get help? If you check the chat, it will be available. I mean, there's a link right there for Tzedek. You can go right to that link, and they will be able to provide some immediate assistance for you. Okay. Other than that, I think that will be all for today. Or are there any other questions? Let me see. I'm going through the chat right now. We will be able to get a recording. You'll be able to see a recording on YouTube, on the YouTube page, and we'll also be making an opportunity. We'll also send a link to those who have registered and make sure that you all have an opportunity to see this again. I see a question in the chat. Will the copy of the slide deck and presentation be available? The slide deck presentation, we will. Oh, so yes, we did answer that. And someone saying, live in Hawthorne, which company do I reach out to? You can start off, and you can go ahead and go to the link for Tzedek, which I left in the chat. The slide deck won't be available, but the video will be. And is there more information on executors, on how that works? Because I hear lots of different options that they've had, they have, and decisions they make. I don't know if any.
An executor is someone who distributes assets pursuant to a will. And so I think if you wanted to talk to us more about, the duties of that person, or what that person, has authority to do, we can certainly answer questions about that. But it's a very specific person with a very specific planning instrument.
Thank you, Dominique. So you can review your eligibility, because this program is a free legal services program, but there are some qualifications, some eligibility. You can go to our link on our landing page, for our DCBA landing page, to get more information on the exact qualifications and eligibility. St. John's, when will St. John's be starting to take intakes? December 1st. That is the hope that this St. John's will be able to start providing intakes. And St. John's will be covering most of South Los Angeles, East Los Angeles, and Tzedek will also be covering all of the surrounding areas around Greater Los Angeles, but also they can also cover areas within the inner Los Angeles area. Okay, I see there's also another question in the Q&A. If someone passes and they didn't have anything like a trust or will, can their heirs inherit the house without having to do probate? I'll leave that up to you two, subject matter
I mean, it
experts.
depends on the situation and how the house was owned, but I mean, the very short answer is likely no. But it depends. The answer is always going to be it depends, I think, but it's unlikely that it could go without probate unless it's owned in joint ownership or community property, or if it's a very low value house. See, there's so many. It depends.
Like a piece of property that's worth, you know, $50,000, which is rare in LA.
Mhm.
Right. And I think because cases are so individualistic, I think it's Mary who wrote this. It would be important to just try to contact either Tzedek or St. John's to try to get more information, because your situation is, everyone has different situations. So I would agree. I would encourage you to do that. Next question you stated was, what if they were a 100% disabled veteran and qualified for the tax property exemption, but I don't think it applies for it before they passed? Can the heirs still have the exemption applied to the property, and do they contact the county to do that?
That again, I feel like I don't know. I'd have to do like a full intake with this person and, you know, see if we're the right organization or if it would be with the assessor or, you know.
Mhm. Perfect. So let me see. I'm going to go to the chat area to see if there's any. How is it determined which company will help St. John's or Tzedek? Zip code. That's the the quick answer is zip code. However, both of these vendors, St. John's and Tzedek, cover a large portion of Los Angeles. So I would just suggest that you just start the process. If you need help today, you can go to Tzedek. If you would like to wait till December 1st, you can contact St. John's, and we will have a landing page and a link for St. John's by December 1st on our landing page, on our DCBA landing page. So just again, as Bertha stated, yeah, just check the DCPA landing page for any upcoming updates.
And since there's questions about the intake process, I would just add from Tzedek's front, an intake process is where we collect biographical information and factual information so that we can determine if we are best suited to assist you and also to determine what your legal issue is. So for some of the individuals asking more specific questions, please know that while we can answer generic terms and help you understand legal concepts during a webinar, in order to provide you counsel and advice, we would need to go through the intake process. So we hope that you'll be able to easily connect with us via the landing pages, and we look forward to serving the community.
Thank you so much, Bertha. Much appreciated. Please check the DCBA landing page to find out all the information about eligibility. There are income, there are family size, qualifications, area. All of that is part of the qualifications. So please go to our DCBA landing page. I did put it up on the chat, way above. If I'm not able to qualify, how much are the fees? And I think that's another question that you would probably have to find out specifically through Tzedek and or St. John's. We'll be able to provide you. If not, if you won't be able to get qualified through our services, we can at least provide you with some sort of referral or some information that can direct you to something where you can receive some services.
Correct. If someone is not eligible for the services under the eligibility criteria posted on the DCBA website, we want to empower you to enter the marketplace to hire either an attorney safely. So we will provide you with other referrals through LACBA Trust and Estates, or provide you to key information from the State Bar and how you can also verify that you're connecting with an attorney that has expertise in the area.
Okay, great. Let me go back to the Q&A and see what questions are there. Mary says, do you only help with LA County? This program is currently for LA County residents. So if you live in the LA County and you reside mainly in the highest high need areas that were highly impacted through the COVID pandemic, then there's a possibility you may qualify. But there are other qualification criteria as well. So please check our DCBA landing page. Also, we live in LA County, but the property is not. So if the property is not in LA County, we may not be able to assist in that regard. But please call and we can probably see where we can direct you to. Okay. And let me go back to the chat. I believe we answered all the questions. Yes, Bertha, did we answer all the questions? I believe we have.
Yes, I believe so.
At the very least, if you are interested in our services, please go to our DCBA website. And if you are interested in learning more, you can register on the updates page that we have. It's in purple. All right. If there are no more questions, I want to bid you all a good day and have a great day. And please look forward to these series of educational webinars for estate planning over the next year, 2024. All right. Take care. Have a great day. Thank you, everyone.
Thank you.